Okay, and I will give it a couple minutes for people to join before we officially get started. Pull up my little intro slide, I think, so people can see it when they log on. You know what, I just realized I said that we could take client questions as we come along, but when I'm in this view, I can't see the questions on the Zoom. I don't think. I'm just seeing, like, this is taking up my whole screen.
That's
So
okay.
you might
That's
be
not a
lying.
problem.
Maybe we will hold the questions at the end.
Sure, that's fine.
Okay. Give it about one more minute. And Chelsea, did you just see that the pop-up on my screen? I think I'm just sharing the PowerPoint, but I just want to check.
No, I haven't seen anything.
It was like
about
a Teams chat, so I just want to make
No,
sure
I don't
that there
think
weren't
so.
other
I know,
things
that's
coming
always-
across.
That's always such a stressful moment for me where I'm like, oh no.
Yeah. Too worried about it, but I don't want like random confidential things being like popping up on my screen. Okay, well, I think we're going to go ahead and dive in. I want to thank Chelsea Ortega so much for being with us today. We're going to be doing a presentation today about managing clients and their expectations, which is the cornerstone of any client relationship you're going to have, whether that is with an MVLS client or with clients in your private practice. So I want to very much thank Chelsea for being here today and for doing this presentation with us. I'm going to do a little bit of introduction about MVLS, and then we will dive into the presentation. If you have questions as we're going, I would invite anyone to put your questions in the chat. We are going to hold the questions for the end. So I will keep track of the questions that come in and we will answer them at the end of the presentation. So just background for anyone who is not already familiar with MVLS, we are the largest pro bono organization in the state of Maryland. We primarily handle cases in Central Maryland, but we do cover every jurisdiction in the state. And the areas in which we handle cases are family law, housing, consumer, criminal record relief, income tax controversy, and estate planning and administration. So we cover a fairly wide gamut of civil legal issues for our clients. Our services are all pro bono. We work with clients who cannot afford an attorney. And so we do have income guidelines that our clients need to meet to qualify for our services as well. And you know, the key to making this all happen is you all are volunteer attorneys. So for those who are on the call, if you are a current volunteer, I want to thank you. And if you've never volunteered with us before, I want to thank you for joining us on this webinar. And I'm going to talk a little bit at the end of the presentation about how you can take a case with us. And hopefully this presentation, you know, will make it a little less nerve-wracking. I know Chelsea's probably going to talk a bit about her experience taking cases from us. I know she has taken quite a few, as well as from some other pro bono agencies. So we try to make it as accessible as possible. I'm always available to answer questions about pro bono cases or volunteering with MVLS and what it's like as well. My name is Margaret Henn. I'm the Director of Program Management here. So I oversee the pro bono program, and please do feel free to reach out to me whenever you want to ask about volunteering and how it works here. So this slide is just a little bit about how you can follow us on social media. That can be a great way to learn more about like what we're doing and what we have coming up at MVLS. So you'll learn about trainings like this one that are upcoming, as well as other events that are going on. And I actually should have put a slide in about this, but one thing that we have going on right now is we have this summer Take a Case campaign going on. We are encouraging volunteers to take a case from us between now and August 1st, which is about a week and a half away. Which will guarantee you an invitation to our judicial reception that we're doing on September 22nd, where we're going to have an opportunity for our volunteers to meet and mingle with some local judges. And I think it's going to be a really nice event. So I'd encourage anyone who is able to take a case between now and August 1st to guarantee yourself a ticket to that event. Okay, so I'm just going to, sorry, my screen froze for a second there. So pro bono cases, how do you take one? Our pro bono portal, this is our website, and you see the word pro bono portal circled. That is where you would go if you want to take a case from us. And I just wanted to, build upon something that we have been talking a lot about at MVLS before we dive into the presentation, which is equity in the law and making sure that we're building equitable relationships with our clients. I think that this really ties into what we're going to talk about today, because we're talking about client relationships. So some of the principles that we've been talking about internally at MVLS are active listening with your clients, making sure, they feel that they're being heard and you're valuing their experience, and they feel that this is a non-judgmental place and a friendly place that they can, come to seek your advice. That is really important because unfortunately, a lot of the clients that come to us have only had negative experiences with the legal system, whether it be the civil legal system or the criminal legal system. And so the idea of going to a lawyer about anything is not necessarily inviting. And I think it's really important to kind of like keep that experience in the back of your mind as you're working with a client. And if someone feels hesitant to open up to you at the beginning, that might be where some of that is coming from. So just kind of an important framework to kind of keep in your mind as you're thinking about these issues that we're going to talk about today. With that, I'm actually going to open up Chelsea's presentation, and we will turn the presentation over to her. So Chelsea Ortega is a partner at Santoni, Vocci and Ortega. She has been a volunteer with us for a number of years now. She is also a board member, and in her practice, she handles a number of different consumer issues, and she is a wonderful supporter of MVLS as well as a wonderful practitioner. So we're really glad to have her with us today to talk about her experiences. And with that, I will turn the presentation over to you, Chelsea.
Thank you, Margaret. And I appreciate your kind words and for having me here today. I can only see the end of your presentation, so I don't know if we need to switch.
Oh, I'm sorry. Okay.
That's okay.
I think I do. Let me try that again, and I will.
Sure.
I've got your presentation all up, and I didn't realize I was the only one who could see it. So we're going to try that again.
That's fine. While you're doing that, I just can't reiterate enough how great of an organization MVLS is. I've been a volunteer for basically my entire legal career, which will be 10 years this year. And I have had the opportunity and benefit of representing some absolutely wonderful people. Some of the pro bono clients that I've received through MBLS, even when to me, just getting them out of a debt, where in my private practice, a lot of times we try to get the client relief as a form of monetary damages for what they've been through. I get cards from the clients, they're so grateful and just thankful that somebody has helped them and taken their side. So it's great for your practice because you have lovely clients who will refer cases and come back to you with maybe paying matters as far as like contingency, a car accident case, for example. It's just a great opportunity for your practice as well as for your well-being, besides the fact that it's recommended that you do pro bono work. So can't say enough about that. If you do have any questions about volunteering and you want to hear from a private attorney's perspective, I'm happy to talk to anyone who has questions or wants to just, talk about what kind of issues or barriers you're facing. If you aren't comfortable with doing pro bono work, then, we can talk that through. So happy to do that. My contact information will be at the end of the presentation. And now I'm no longer on MBLS CAN. I think this is my last year, but it's a part of MBLS and it's a network of young attorneys. So if you are a young attorney and you've never done pro bono work, feel free to reach out to me. But it's a group of us who are have been practicing for less than 10 years, and we support one another, and there's also mentoring and shadowing opportunities there. So if you fit into that category as well and have questions, please feel free to reach out and let me know. As Margaret mentioned, I'm a partner of Santoni, Vocci and Ortega. We're located in Baltimore County, but we handle cases across the state of Maryland. We handle both individual cases as well as class actions. The class action cases generally center around fee issues and tenant cases, but have involved repo cases and a variety of matters. We represent tenants, consumers, and personal injury victims for the most part. So this presentation today will provide strategies to manage clients. I will discuss red flags, which may indicate that you should not represent a particular client, and ways to ensure that you are communicating effectively and frequently with your clients. At the end of the presentation, I will discuss different scenarios that routinely arise during representation and how to handle those issues to ensure that your client has reasonable expectations of the representation. So moving to the first slide. First, why is it so important to manage your client and their expectations? This may seem like an obvious question, but it is one worth asking and considering. That's because unless you can build and maintain a positive relationship with your client, he or she is not going to listen to you or follow your advice. You will find that you are just butting heads throughout the entire time, and it makes the job much more difficult than it had been if you would do some of these things that we're going to talk about today. Often your clients just want someone to talk to explain what they are feeling and going through, and they are thankful and grateful if you can be that person. But there is a balance of making sure that they know what's going on in the case without you or your staff talking to them on the phone or contacting them every day. And so that's what we're going to talk about as well, is how do you find that balance where they are informed and happy, but they're not driving you crazy or your staff crazy. And so we'll talk a little bit about that. But that's also why keeping them informed about the status of their case is important and will save you a lot of time and grief in the long run. It's also important to keep in mind that the legal process is often a novel and stressful experience for clients. And Margaret talked a little bit about this in her intro. It's important to keep this in mind because as attorneys, we often forget this because we're in it every day. But it's our job to make the process as easy as possible for our clients. People often do not react well when they are stressed or feel backed into a corner. The more you can put your client at ease, the better they will react and the easier the relationship will be. Now, this last bullet point, getting to the magic language of whatever you think, this is my favorite phrase to hear from a client. By the way, we talk about this a lot in the firm because thankfully we do hear this a lot where the clients do trust us and trust our judgment. It doesn't mean that you don't continue to consult the client at critical points in the case, but rather refers to when you are in that settlement posture or when the client does have to make some crucial decision in the case. And the fact that you and your client are fully on the same page and the client defers to your recommendations, whether that's settlement or some other event. And this not only does it make your job so much easier because you don't want to be fighting your clients and opposing counsel, but if you're at that mediation or settlement conference, I believe that the mediator or the adjuster and opposing counsel, they can tell when your client fully trusts you, and the jury, if you're going to jury, they can absolutely tell if you have a good relationship with your client. You can often get a better result if they can tell that your client and you are on the same page, and they can tell if your client's going to be reasonable too. So not only does this help you in your job, but it also helps the client's case just to get a better result for them if you are able to maintain a great relationship and manage the client and their expectations. Moving to slide 3. Now, this is not a presentation on ethics, but I would be remiss if I didn't point out a few ethical rules that represent a lot of what is going to be discussed today. In all the ethical seminars that I've attended, I've heard that one of the most common reasons attorneys receive grievances is due to lack of communication. And that's why so much of this presentation is focused on client communication, because keeping the client informed is one of the best ways to manage your client and keep the client happy. When the client doesn't hear from you or know what's going on, that's when, unfortunately, attorneys get a call or a letter from grievance, which is never pleasant and you want to avoid, obviously, at all costs. So therefore, not only is it important to tell the client what is going on to maintain your relationship, but you're also ethically required to do so, which is why I've listed all the rules here and won't go through them. But I do think it's important to keep some of these in mind throughout your the representation of the client. Now, as an attorney, you should be thinking about managing the client and their expectation from the very first contact that the client has with either you or your office. Now, this may involve training of your staff, but this can often set the stage for the rest of the representation. One way to do that is to make sure that you or your staff give time estimates for returning client phone calls, for reviewing documents. Basically, those first kind of initial things that are going to be happening, you want to tell the client, okay, it's going to be, or your staff may say, the attorney is going to review the information. Maybe they take an intake. It'll take X number of days before you'll hear back from us. And that way, the client, number one, isn't calling every 5 minutes saying, have you reviewed my case yet? Have you reviewed my case yet? But it also just sets the stage as far as like, okay, they're going to tell me when I should hear back, when I'm going to hear a response. And they respect that, number one, because often they've never been through this process before, so they don't understand. And so they're grateful that you've told them what to expect. And then as well as the fact that it'll set the stage for later on. So they'll know, okay, well, she's going to tell me, my attorney or the office is going to tell me when I should expect to hear back, and they will usually follow that. They won't call before that time period ends because you've already told them. And then you also want to explain just your firm's intake process if you have one. Are you going to review documents or before meeting or retaining the client? If so, how long is that going to take? Is the client going to electronically sign a retainer agreement without a meeting? I personally am a strong advocate for in-person meetings. Number one, because I think that it's difficult to build rapport or trust with a client when you're conducting a telephone or even a Zoom meeting. Number two, because often with pro bono clients, that can present an extra barrier because the clients aren't always sophisticated enough to be able to figure out a Zoom link or maybe even phone numbers and things like that. So in appointment times, if you have, either you go and meet with them somewhere that's convenient for them or have an in-person meeting in your office and some reminders. I just think that that's both easier for the client. They can just bring their documents with them rather than trying to figure out how to send them to you in advance. All of these can be difficult things for low income or pro bono clients to achieve. And I will say that during the height of COVID, our office was doing many initial meetings remotely because, it was scary. Nobody knew what to expect or what was going on. And we found later that several clients simply just weren't truthful. And we believe that if we had been in person, they may have felt more comfortable sharing the truth. And ultimately, it tanked their case because we had drafted things and said that this is what happened and this is the truth. And it came out later that it wasn't. And that was unfortunate. And I really believe that if we had been in person and been able to, build that rapport and trust and say, look, I don't care. I don't care what the truth is. I'm not going to, as Margaret said, I'm not going to judge you for that. I need to know to give you the best chance that you have. And the truth eventually is going to come out. So, let's talk about everything now in the beginning when we're, before we sign answers to interrogatories and under oath, what actually happened. And I think the best way to get that information is to do an in-person meeting from the beginning. Then finally, during the intake process, ask the client, how do you prefer to receive communications? And make a note of that for the future. Then you aren't sending emails to them for months and months thinking they're receiving them, you're updating them as you should. And then you get an irate call that they haven't heard from you for 6 months when you thought everything was going great. So part of our intake question is always, how do you want to be contacted? And they'll write it down, is it by phone? Is it by email? Do they have a computer? These are all things that you need to understand to fully understand the client and how you can best represent them in their case. The final thing that's not noted up here, but I'm going to talk about it a little later, is to also have an emergency contact when you first do the intake, is find out either an alternative way to contact them, by phone or another email, or to get, what we really prefer is to get some kind of person who we can call if we haven't been able to get a hold of a client and say, hello, I haven't been able to get a hold of, your sister or mother or brother. Can you please let them know I'm trying to reach you and give me a call? And you don't talk about, the circumstances of the representation or anything like that. And you obviously get consent to contact the person if you haven't been able to get a hold of them. But unfortunately, a lot of times we see with low income clients that their phones get shut off or they get lost, or maybe they've lost their email. I haven't been able to get into their email. So always get an emergency contact as well. Unfortunately, sometimes there may be nothing that you can do to manage a client, and the sooner you know that, the better. I've listed here some initial, red flags that in my years of practice, anytime this occurs, now I just won't represent the client. So the first one is if they're difficult or rude to the staff, or you, then it's not going to bode well for the future representation. And it also makes your staff unhappy. So you don't retain clients who are angry or mean in the beginning. Your staff won't thank you for it. And then not only do you have an angry client, but you have angry staff. So you're being fought on all sides. Also beware of any potential clients who refuse to answer intake questions, basic questions like their phone number or even their full names. You can bet that if this happens, they're going to be resistant to providing information throughout the case, including answers to interrogatories and depositions. There's not much that's worse than sitting in deposition and the opposing counsel asks your client a question and the client says angrily, why do you need to know that? Or refuses to answer basic questions like their address. It makes for a very long deposition, and also it just doesn't make any, they're entitled to ask those questions. Doesn't make any sense. If the client refuses to talk to the staff and demands to talk to an attorney right away, you also are likely not going to be able to make the client happy. And sometimes those potential clients can be saved if the staff is, trained to explain to them, this is the way the process works. The attorney is going to review that information and get back to you. And like we said before about those time expectations in the firm intake process, hopefully you've already done that or your staff have done that. But if they still are adamant that they have to talk to the attorney, then I just tell my staff, I'm sorry, we're not going to be able to help you because they're not going to be reasonable and they won't comply with the systems that we set in place. And sometimes we'll say to them, like, you don't call the doctor's office and demand to speak to the doctor right away. We're in court, we're in hearings, we can't talk to them at that moment. And if they won't understand that, then they're not going to be a good client. The final red flag I have listed here is when the potential client starts quoting the law to you. They will send sometimes a long rambling email that the defendants have violated such and such section and they're entitled to punitive damages of $1 million. Long rambling emails of more than 3 pages are also a red flag, by the way. But that never bodes well either, because they've already done their research and they know what they're going to get, and you're not going to be able to convince them anything else. So if the client, like I said, is demonstrating any of these characteristics or behaviors, it doesn't matter how strong the case is. If they even, got hit by the Walmart truck in the crosswalk, I won't represent the client. There will likely be conflicts between you and the client in the long run, or the client will simply drive you and your staff so crazy that it won't be worth it. Some other factors that may have you think twice before representing the client, but may not be a strict, will absolutely not representing them, I've listed here. One of them is whether they filed suit or submitted their own demands before they come to you. My partners and I differ on our view of the situation, but I will almost never represent the client if he or she has already filed suit, because now you have to undo any potential harm the client has already done. It just makes it more difficult right from the jump to represent the client. Obviously, it's different for pro bono clients. If you're jumping in to help them, that's something. And there are, limited scope rules that maybe you just agree to help them with a specific part of the case, like the answers to interrogatories or depositions, something like that. And that's fine. And you should have a clear agreement, obviously, that complies with the rules if that's the case. But a full case, like from beginning to end, where I'm going to go in and try it, I typically won't do that. Now, like I said, my partners they differ on that. So that is a personal preference, I think. I don't personally care about criminal convictions, but you need to be aware if the client has been convicted of any crimes of moral turpitude within the past 15 years, such as theft, because those will be admissible in court and may affect the credibility of the client. This may be more important when it's your client's word against the opposing party's word, such as a he said, she said situation, but it is something to be aware of and make sure that you know about it, particularly if there's a question and answers to interrogatories or depositions. Bankruptcy can sometimes have implications in a case, particularly if the client files for bankruptcy during your case. So you always want to ask if they have filed recently or are considering filing in the near future. We also include this language in our retainers that they will advise us if they file for bankruptcy. It's not happened to me a lot, but whenever it does, it's not been great when the client files for bankruptcy while you're in the middle of the case. So you want to find that information out. Multiple plaintiffs can be challenging, especially if things go south between the plaintiffs while you're in litigation or in a conflict arises. Unfortunately, we've had several breakups and divorces in between the plaintiffs, and it makes sense with COVID. And it's also because a lot of times they are in a stressful situation, whether it's dilapidated housing or facing, eviction or a collection lawsuit. That can obviously add a stressor to the relationship. And unfortunately, sometimes they end and it's not a very pretty ending, which can impact your case. So make sure you have conflict language in your retainer if there are multiple plaintiffs, and just be aware that that's something that could happen in the future. The last consideration is if the potential client has fired their prior attorney in the same matter. If you ask this, which you should, or know that from what the client's told you that they had an attorney before, I would ask lots and lots of questions about the reasons why the client decided to retain a new attorney and to fire their prior counsel. It's often a good way to determine whether the client has realistic expectations. So we've had them say to us before, they didn't do any work on the case. I signed up the retainer and signed a retainer with them, and I called them the next day and they hadn't done anything. So, they gave the attorney one day to start working on the case. It's probably not reasonable. They are going to treat you the same way. They're not going to treat you any differently. So just ask lots of questions. Sometimes it is legitimate. They took my case, they waited a year before they did anything. That's very fact specific, but you want to find out the reason why. So if the potential client has made it past the intake stage and doesn't have any significant red flags, the next chance you have to make sure your client will be reasonable is when the client signs the retainer agreement. This is another opportunity to discuss time approximations, especially with COVID. I will explain that a trial date could be 2 or even 3 years out, that the hearings could be canceled unexpectedly, or the trial could be moved with very little notice. Unfortunately, this is the reality that we live in right now, and it's your job to explain that to the clients. There's nothing you can do about it. And if you tell them early on, then they've at least heard it once. So when it actually happens to them, then they will be less surprised and again, acting out and angry with you versus just like, this is the world we live in. It's unfortunate, especially if the client has already been waiting a really long time for their day in court. It's unfortunate, but you should tell the client this, when they're signing the retainer agreement or you're getting that arrangement worked out. You also want to discuss the next steps and what types of tasks you or your office will perform on his or her behalf. For example, in a personal injury case, this could be ordering medical records, police reports, talking to the adjuster, and this serves a number of goals. Number one, it offers a reason for them to go with you, to have them retain you as your attorney. I'm going to do all these things for you. You're not going to have to worry about, this and this and this. We're going to do that for you. And number two, they won't expect you to do things that you haven't talked about. So, a good example is in a personal injury case, often the attorney will represent the injured client, but will not handle the value of the issues over the repairs to the car or anything like that, not the property damage claim. So unless you tell them what you are going to be handling and what you're not going to be handling, they don't know that. So it's very important to set that out at the retainer stage so that they know what to expect moving forward, and they won't get mad later or have unreasonable expectations when you tell them, well, I'm not doing that for you. And you should also have in your retainer agreement, specific things that you're going to be doing, investigating, filing suit on or whatever it is regarding this matter. But you want to explain that to them as well, not just have it in the retainer agreement. It's important to keep in mind, again, that they haven't been through this legal process before. They have no idea what to expect. So it's your job to explain to them what is reasonable. This is especially relevant given the rise of the internet and crime shows. You have people who think they know what to expect or what they're going to get. And the more you can explain what the case is about, what you are going to do for them, what they can expect to receive, is just as far as even the form of relief, is that money damages? Is that an injunction? Is that, what is it? The easier the relationship will be. What's one of the best ways to find out what your client expects? By asking them. I will often ask, if you could wave a magic wand, what would you want out of this? That helps you to find out early on if they're expecting $1 million, or sometimes we'll hear already, I don't know I'm going to follow whatever you think. And so that already is helping you to determine, okay, I can work with this person, for 2 or 3 years possibly, or longer, because they are going to have reasonable expectations and listen to what I'm going to say. Some other things to consider when you're at that, still gathering information, they're signing the retainer is, have they had a former case and gotten a certain amount of that settlement, or have they had a bad experience with an attorney or the court or a judge that has soured the entire legal system for them? As Margaret discussed, most people have had negative experiences with the court. This is particularly true for tenants who go through the rent court process. And they've only had, maybe 30 seconds to explain why they didn't pay the rent. If the judge hasn't already told them, well, if you owe the rent, I don't care, I don't want to hear about it. So that's why it's important to talk to them about, have you had prior cases? And if they say, yes, and I got, X amount of that one, I expect to get that amount out of this one. You can say, well, explain that cases are very different and fact intensive, and maybe they had medical bills that were totaled this amount, or you can explain even that times have changed as far as what adjusters pay now versus what they paid even pre-COVID. But those discussions should take place at the initial stage, not when you're trying to settle or resolve the case. Because if you're not going to be able to bring them around to your thinking, then you want to know that as well. Particularly for particularly for pro bono clients, there may be many barriers that you should always keep in the back of your mind. The client, especially from the retainer stage, the clients may be illiterate. I will often read the retainer agreements to my clients because they're too ashamed to say anything that they, aren't able to read at that level. This may, also impact if you do send communications later. You need to note that, like, I have to always call them to let them know what's going on versus sending an email or a letter. So if you do suspect that, then particularly you should note the file and keep that in mind for the future. They may have mobility issues. They may be late for appointments because they missed the bus. You may have difficulty reaching them because they've, again, lost their phone. And these are just things that you should keep in mind. So I think most people are hopefully good about this, keeping this in mind, but particularly for pro bono or low income clients, you have to give them a little bit of grace because they're just trying to make it. They're just trying to stay in their house and hold it together. And because they're running 15 minutes late, you shouldn't cut them loose. Give some grace, have some empathy, and keep in mind that, they have a lot of issues, a lot of times going in. Mental health issues can also be a barrier and can make it difficult to represent clients, but keep that in mind as well. I've provided on this slide some sample language that we have in our retainer agreements. I know it's small, but the first one is about, being reasonable, the client agreeing to be reasonable with their contacts. We're not going to be able to respond immediately. And I will often read this to the client and they'll chuckle like, yeah, I wouldn't call. That's ridiculous. I wouldn't anticipate that you would call me back right away. And I'm like, okay, as long as we're on the same page, that's fine. But, now with text messaging, I think people do expect like, oh, well, I called you this morning and now it's 1 o'clock. You haven't even called me back. And so I will say to people, I'm often in court. I'm often, in depositions. I'm often in, hearings or meetings. And so it may be, X amount of time before I get back. And typically I say, I try to get back to people within 48 business hours, 2 business days. But, even then I might be out of the office. So, and if you explain that again early on, then it helps later. The other language that we have is that we can't make any promises about the result in the case. I just think it's great to reiterate that in the retainer, particularly if something does come up later on, then we can say, Mr. Smith, remember when we signed the retainer agreement back on, X day, you agreed that I couldn't make you any promises and that, I can't tell you how much you were going to get. Typically it's not an issue, but I like to have it in the retainer just as a backup. We also have in there language about the complaint, maybe more than what the client ultimately receives. And so it's particularly in the Maryland rules because it's, in excess of 75,000. If it is, then, sometimes they'll add up all the 75,000s and say that that's what it is. So it's important to make sure that they understand if you are going to file the lawsuit, that they understand what that means, especially when it comes to the values. Because a lot of times that's where the clients will hone in. They don't care about everything else. They just care, what they're going to get, which is fair. But you have to keep that in mind too. This slide just shows we provide our personal injury clients at least with a list of reminders. And this ensures that we don't forget anything important to advise the client, as well as it, lets them understand like they have responsibilities too. And this is what we're going to do and this is what you should do. So this just helps to make sure that the client knows like what they are going to be doing throughout the case. Because without their cooperation, and we can't, continue the case. So this is good to, not even if you have personal injury cases, but any practice you have, you can create a template like this or a list. And then once it's done, once you have it for all your clients, and then you will make sure that the client has reasonable expectations, hopefully, based on at least, what some of the things they should be doing. And part of this is you want to avoid a situation later where they say, well, you never told me that I was going to have to, let's say, like, go to my doctor or follow up with my doctor. You never told me that. And you'd say, here's the list we give to every client. I have it in your file too. So I did. And sometimes you can save them. They're like, oh, that's right. I remember now. I'm sorry about that. I've had people say that to me. And then sometimes, unfortunately, they'll say, I don't care. You never told me that. I don't care what you say. But sometimes this has helped to save those disagreements later. Now, as you go through the case, it is important to note whenever you talk to the client that and what you discuss. So sometimes a client will say, similarly, I haven't heard from you in months. And that's when you can remind them, no, Mr. Smith, I talked to you two weeks ago. Remember, we talked about we were waiting on the medical records or waiting on the housing records. And this will often help to avoid issues. And the client will say, oh, that's right, I remember now. Unfortunately, if there is an issue, it's also good because you'll have a record of all of your conversations. So hopefully, you don't get a grievance, but if you do, you have a long, nice list of all of the times that you talk to a client and what you explain to them. And so it's best practice to have that. The other a good habit to establish, in addition to making sure every conversation is recorded somewhere, is to inform your clients whenever a major event occurs. So when I get, the summons back from the court, I send the client, that's my cue, send the client an email. I got the summons back. This is what you can expect next. Again, giving those kind of next steps, expectations. We serve the defendant. Anything like that, where you're getting anything from the court or opposing counsel, that should be your cue to send something to the client and let them know. And it seems kind of intuitive, but I've seen it happen where the client just isn't notified. And so you should, like I said, make it a habit of whenever something comes in, make sure you or your staff is letting the client know about all these major events that are happening in the case. And I would recommend.
Oh, sorry, go ahead. No, I was just going to jump in with a question, but
no, go ahead.
Finish your sentence. For a situation, you mentioned that for some of your cases, they're getting set, 2 or 3 years out because of the courts right now. So a situation where there isn't much going on in the case for a period of time, how frequently would you recommend that an attorney would check in with the client if that's the case?
So what I would do in that situation, like, for example, if the case is on appeal and we're just waiting for, the decision to come down, I would say if we know, maybe you won't know an appeal, but if we know about how long it will be until the next step, I will say it's going to be approximately, 90 days or 30 days before I hear something on this. Check back in 30 days, 90 days or whatever. And that way it almost puts it on them, but also then they know, like, okay, there's going to be a big lag in when I hear from you. And so they've already been informed of that and are aware of it and are, not expecting to hear from you. That's typically how we handle it. Or we'll just say, we don't know how long it's going to take. Check back every 30 days or whatever the timeline is reasonable. But that helps to then put it a little bit on them. And then sometimes, periodically, we will just send out an email. We're still waiting on the decision. There's nothing we can do, unfortunately. Or we'll try and do something and let the client know. And if you have, that's maybe good where you have a a case management system or a tickle system to tell you, it's been, 3 months since you opened up their file. Then if you have that system in place, that can be helpful to avoid those lags in communication too. And I would recommend getting some kind of case management software if you can to help you with that. Great question. Important discussions such as settlements or dismissals should be memorialized in writing. especially if it has been kind of a difficult client, or maybe the client does have some kind of mental health issues, or is elderly and does forget things. Obviously, if it's to a point where you need someone appointed, that's a different matter. You should, if you have someone who can't make decisions, that's different. But otherwise, make sure that you are putting something in writing, an email or letter, to memorialize that. So now, once you've explained to the client what you're going to do in their case, be diligent and work the case. So that means, not sitting around for months and months and waiting to send out a letter of representation or calling opposing counsel. The client is not going to be happy if you have no update and it's been 6 months. Establish clear processes and expectations with your staff, or with yourself, if it is you, or with the client, and say, this is how long it's going to take to do this. If you're slammed in a trial, tell the client, I'm going to be slammed in a trial for 6 weeks. I'm not going to be able to do that until this time period. But you need to be upfront with the client and let them know that ahead of time, so they can make a decision whether or not they want to retain you or not. So work up the case, make sure your staff is working the case, and the client will appreciate that. Make sure you're attentive to your client. If he or she mentions something important in their life, even if not relevant to your representation, make a note of it. Are they expecting a baby? Ask when the baby is due and send a gift or a card. Are they going on vacation or a trip? Well, make a note of that and, ask about it the next time you talk to them. It makes a real difference when you, are interested in what's going on in their life and the client knows that. And that goes a lot to, I really appreciate what Margaret talked about earlier in the intro about, valuing the client's experience and active listening. The clients do appreciate when you ask questions about their lives. And then when you bring it up later, they appreciate it and are grateful that you are listening to them and taking an interest. It's human nature that people like talking about themselves. So ask the client questions about their life and their family, and make a note of it to remember to bring it up later. We also, and this is a little bit sidetracked, but we will often meet in the client's home, especially if we're going to trial. If the client is comfortable with it, we'll meet in their home so we can get a clear picture of, what they go through every single day, whether it's, they have children or maybe they take care of an elderly parent. You get a feel for, you see how all of their family pictures around, and you ask questions about that. They really appreciate that. And that means that you are going to help your relationship with them, and they're going to listen to you when it comes to settlement decisions or trial decisions. Don't just be attentive to your client, but also to the work. Make sure there's no errors in your letters to the client, no sloppy mistakes. It does matter. The clients, see that if you make a mistake and they're like, oh, you put dear Mr. Smith, my name is Mrs. Smith, or, nobody wants that. So make sure that you're paying attention, and that everything that goes out, hopefully everything that goes out the door is, tip top shape, but especially to the client, make sure that you're paying attention. Unfortunately, if there is a mistake, be honest and explain to the client right away. Take responsibility. Don't blame your staff or someone else for what happened. You are ultimately responsible. So make sure that you do that. And if you've had that good relationship, the client's going to understand, and you'll work it out. Just quickly, here's some, if you do want to try and automate these client touches, we talked a little bit about that, create some templates, a welcome letter, suit's been filed letter, suit served, closing letter, a little bit what we talked about before. That'll just make your life easier as far as you've drafted them once, you don't have to worry about it anymore. And it's a reminder, every file should have these, update letters in the file. And if they don't, then there's something missing. And checklist can also be a good way of just making sure that you're informing the client about what's going on and keeping track of the case and next steps. Settlement discussions with your client should happen early and often. So, sometimes from the very beginning, what do you expect, again, out of this case? Discuss any deal breakers. So the client may say, I do not want to agree, to a non-disparagement clause. I want to be able to talk about what they did. Discuss that early, so then and you can tell opposing counsel that from the beginning, we are not going to be signing a non-disparagement clause. Explain to the client common settlement terms in the beginning or in the retainer. So confidentiality is a big one for us with consumer cases. We don't always agree to that. So talk to the client about those common settlement terms so that they're aware later on, and it's not the first time they're hearing about it. And it also just helps to manage their expectations. Again, this is what you can expect. This is the settlement agreement may contain these items. And if they're like, no, absolutely not, then you can either work with them or you can't. But at least you know that early on, and not at the end of the case after you've done all the work. If it's going to be a deal breaker, then that's very unfortunate. So hopefully you've followed all of these tips in your practice. Your client loves you, their family loves you. So you should take advantage of that and make sure that you ask them for a review. We'll put QR codes on closing letters so clients can just scan it with their phone and leave a Google review. Make it very simple for your clients, put a link in an email, but ask them. If you don't ask them, then you're not going to necessarily get it, or at least get the reviews from the stellar clients. And then send regular communications for repeat business and referrals. Send them birthday cards, send a newsletter. Sometimes we'll send, it's been, a year since we closed your case. Have you checked your credit? If it's a consumer case, make sure that the debt is off of there if that was part of the settlement. And sometimes that can be a second case. So, the more you touch the client after they've no longer become your client, the more likely they are, if they unfortunately do have the case, will come back to you or refer their friends and family, because you have done such a good job of making the client happy and getting to know them, and they've trusted you with their case, that they're going to bring back more cases to you or refer their friends and family to you. So I've just got a few scenarios that I wanted to go over. The first one is you're meeting with your client and you're discussing the retainer agreement. The client asks, how much do you think my case is worth? How much am I going to get? How do you respond? So it'll be interesting if you do have an answer, if you can put it in the chat, how you personally will respond. I'm going to talk about how I do. So I will generally avoid giving a case valuation at the initial meeting. And that's because there's facts that I don't know yet. Maybe they're still treating if it's a personal injury case. So it's almost impossible to know, if maybe they're ultimately going to have surgery or something. You don't know. And so I just explain all of those things to the client, and I really try to avoid giving a number, because they're going to remember that forever. If you give them a number and if case goes south a little bit or something like that, they're going to be mad and maybe have unrealistic expectations. The second scenario I have is, go to the next slide. The case is in the middle of settlement negotiations. So let's say you've already given your demand, they've given a counter, maybe you've gone back and forth a couple of times. Then the client begins insisting on a higher settlement demand, higher than you've already given. So increasing the settlement demand based on, now the client has done some research of trial results in other states, and their family has told him, things like, well, I got injured and I got this much in my case. What do you tell the client? So, I will often have to explain, not often, but when this comes up, I'll explain there are differences between Maryland law and Texas law or California law, what we can get in Maryland versus other states. I will often bring the client in at that point to have that discussion, and not just like shoot off some email. I'll meet with them. Sometimes I'll meet with the family, especially if the family, is very close. If the client agrees to that, and just talk it out and explain the process again, and explain why there's a difference between maybe their family's case or prior case and the current case, and try to get that resolved, because you don't want to be at the end of the case and now suddenly the client is unreasonable. Hopefully you've done enough to, Jane says, my other partner, marinate the client. But it sometimes happens that they just start talking money and they become crazy. So bring them in and meet with them one-on-one and talk about it. So that's my presentation. We have a couple minutes left for questions. My contact information is here. Feel free to email or call if you have any questions about anything that I presented. If you want samples of retainers or letters, anything like that, I'm happy to give it. Or again, if you want to talk about my experience with MBLS and the wonderful clients I've represented over the years, pro bono clients. Do we get any questions, Margaret?
Thanks so much. I'm gonna stop the screen share and see if I can see anything in the chat. I don't have any questions yet, but I'm gonna talk just for a couple minutes, like wrapping up, and I would encourage people, if they do have questions, to put them in the chat in the next 2 or 3 minutes, and then we can try to adjust them before we end the presentation. So one thing I actually wanted to mention is just like, if you did take an MBLS client and then you have various kind of issues, red flags or something coming up, what do you do? And we want to be here as a support for you, our volunteers. So I would say, first and foremost, please reach out to me or Makisha Gibson, who's our pro bono program manager, or the paralegal that originally sent the case over to you, and let us know what's going on. Because a lot of times we can kind of reach out to the client and try to address whatever's going on. Like an example that Chelsea gave during the presentation was one where the attorney is communicating by email, and then the client, accuses the attorney of never contacting them. Like, that is the kind of thing that we see come up from time to time. And that is the kind of thing that our team at MBLS can hopefully help you work through with the client if, if you're having issues getting that fixed yourself. And like, yes, there are some situations where you're not going to be able to continue with the case, but there's also situations like the one I just described where, okay, we can probably like work through resetting the client and attorney expectations and make that relationship work. So we want to be here as a resource for you. And I just wanted to mention that also, if there's a situation where like really you don't think the relationship's going to work for whatever reason, I would request that you do reach out to us before you just go ahead and, let the client know that you are terminating the relationship, if that's the direction that you feel that you need to go. Like sometimes, like I said, we can work things out, but sometimes it doesn't make sense. And we do, for instance, have a client terms and conditions as an MBLS client that we have the client sign that are with our expectations for what we expect out of clients in the program. And so there are some times where a client can't adhere to those for whatever reason, and we do need to terminate the relationship. But we would definitely appreciate kind of working through that with you if there's something like that would come up. And one last thing I'll say on that is that, unfortunately, because we do have so many clients come in the door every year, thousands of clients, and there's a limited number of attorneys who are available to take cases pro bono, we often are not able to reassign a client to another attorney. So that I just like to make people aware of that, because there's not a lot of option of like, oh, this isn't working for me, I'll just give it to MBLS and they can find someone else. Like that is often not feasible. So just to that is part of the reason we really do try to kind of resolve what's going on if it is resolvable, but we understand that sometimes it's not.
Yeah. And I'll say too, like if I've had trouble even like getting in contact with a placement from MBLS, I'll reach out and say, I haven't heard from, so-and-so. And they'll say, someone from MBLS will often say, I'll reach out to them myself and see what's going on. And that helps to expedite the process. And really the red flags, I don't know if I've seen them mostly in my pro bono clients. My pro bono clients are so grateful and thankful that like someone is going to take their case, that like they're wonderful. So this is mostly like my personal clients in my firm that I'm talking about, where, you may want to be more choosy, whereas pro bono client, they don't really have any other options.
It does happen. I'm not saying it never happens, but like you said, there's a lot of times we're able to reach out to the client ourselves and like work things out. I will just really quick, I don't see any questions in yet, but I will really quick kind of wrap up with one more reminder about how you can take an MVLS case if you are interested in that. So this is what our pro bono portal looks like. You can sort cases by the type of case that you're interested in, as well as the county that you're interested in volunteering in. And if you see one of these cases that you might want to take, you can hit the button that says learn more. That would generate an email to one of our paralegals who can answer any questions for you or provide you some more information about that case. And I also wanted to mention that if you enjoyed this training, we have trainings on every case area that we handle, and other business skills, attorney skills as well, available on our website. We record all of our trainings and make them available after the fact. So I'd encourage you to visit our website if you are interested in that. And if you're not a volunteer yet, you can also sign up to volunteer on our website. And here's the link for how you do that. So I hope you will consider volunteering if you have not volunteered before. So with that, Chelsea, I don't think we have any more questions, but I wanted to thank you so much for being with us today and for the presentation. It was extremely helpful, and we really do appreciate your time.
Thank you. And thank you for everyone who attended.
Thanks so much. Bye.